Mr. Lockhart, have you looked into the um, no more authorities required. That's a very simple issue. And as far as Mr. Manan is concerned, this is the second time. Evidences I have already gone through. Nobody has incriminated the petitioner till now, number one. Number two, have you seen the arrest memo? Have you seen the notice? Where is the ground? Where is the ground? No. There are already 3-4 decisions of this High Court on the point following the apex court, and this court is bound by the apex court decision. The apex court decisions are very clear. The ground has to be something in detail. It cannot be just in terms of the FIR. What is mentioned is only the reference of the case. It is there in the Justice Oka's judgment. It is there. Then, Mr. Locker, there is no point of keeping these matters pending. It's a no, what at where is the stand copy? We have this court has given you sufficient time. Everything is before this court now. The notice issued under 50 CRPC, reference so and so case under section so and so, to so and so, you are hereby informed that you have been arrested in connection with the above reference case. Since the case is non-bailable to police, so you are forwarded to so and so, you may submit petition before the court for your bail. Is this sufficient? Similarly, the other, how many petitioners are there?
My case one.
You are Mr.
Ajibur Rahman. Ajibur Rahman.
Ajibur Rahman, this one. This is the 50 CRPC is the notice, correct, Mr.?
No.
And is there an arrest memo?
There is also an arrest. In some cases, they give the arrest memo. In certain cases, they don't even give it.
Here, an arrest memo is given. Yes, I can see. There. Ajibur Rahman.
Yes.
Date and time of arrest. That's it. Nothing else. I think, Mr. Locker, in all fairness, I think now your investigation officers has to be careful, number one. Number two, if it appears that these kind of things are going on, then it would be time when you must make out a way of, if they don't give all these communications, then they can be made liable. Because if you don't, then sometime it can be misused. They can misuse this power. I don't have to say much. But at this moment, the decision of the apex court is loud and clear. We cannot do anything much. Both Prabir Purkasto and Vihan Kumar. Mr. Manan, you have Vihan Kumar.
Yes. I have given that.
Yeah, do you have a copy?
No, I have already given all.
Do you have a copy
I have
for
a
yourself?
copy. Yes, I have a copy.
Just the conclusion paragraph, can you just read?
Just normally paragraph.
Paragraph 21. I am aware that various petitions will be flooded now with taking this ground, but if it is not followed, it's a constitutional fundamental violation. Consequences has to follow. Please read.
pertaining to the person. Therefore, it is in the facts of the case. We have no hesitation in holding that the arrest to the applicant.
No, para 21.
21, but 20.
Therefore, we conclude.
Oh, just so. Therefore, the conclusion. Yeah.
Conclusion is important. Mr.
That
Lockhart, please have a look at the conclusion.
Therefore, we conclude the requirement of informing a person arrested of grounds of arrest is a mandatory requirement of Article 22(1). The information of the grounds of arrest must be provided to the arrested person in such a manner that sufficient knowledge of the basic facts constituting the grounds is imparted and communicated to the arrested person effectively in the language which he understands.
1 second. Mr. Lockhart, can you justify this in that notice? No, you cannot. You simply cannot. There is no facts mentioned. Simply said so and so case. That is not sufficient. Yes, please go ahead.
The mode and method of communication must be such that the object of the constitutional safeguard is achieved. When arrested accused alleges non-compliance with the requirements of Article 22(1), the burden will always be on the investigation of officer agency to prove compliance with the requirements of Article 22(1). Non-compliance of Article 22(1) will be violation of the fundamental rights of the accused guaranteed by the said article. Moreover, it will amount to a violation of the right to personal liberty granted under Article 21 of the Constitution. Therefore, non-compliance with the requirements of Article 22(1) vitiates the arrest of the accused. Hence, further orders passed by a criminal court of remand are also vitiated. Needless to add that it will not vitiate the investigation, charge sheet and trial. But the same
But at the same time,
filing of charge sheet will not vitiate a breach of constitutional mandate under Article.
even if a
21.
charge sheet is filed also, it will not. Yes,
When
then,
an arrested person is produced before a judicial magistrate for remand, it is the duty of the magistrate to ascertain whether compliance of Article 22(1) and the mandatory safeguard has been made. And
this is
when-
most important.
yes, and when a violation of Article 22(1) is established, it is the duty of the court to forthwith order the release of the accused. That will be a ground to grant bail, even if statutory restrictions on the grant of bail exist. The statutory restrictions do not affect the power of court to grant bail when the violation of Article 21, 22 of the Constitution.
All right.
is
Heard Mr. Y.S. Manan, learned counsel. Huh? Yes. Mr. Counsel, can this court now interpret the decision of the apex court? Please show me an authority that this court can interpret the decision of the apex court. You first show me a decision. Can this court interpret the decision? Now, if I cannot, I have to follow it. You go file review before the apex court. File review.
that one point
File review.
which my learned friend has stated, that is there in Bhyan Kumar paragraph.
Mr. Lockhart, you are an officer of the court. You have to be sometime fairer. Yes, I understand. It is going to open a Pandora's box. But can this court, sitting in this proceeding, now start interpreting the orders of the apex court, which are absolutely clear? Then the decision is very clear. And 3 or 4 of the coordinate bench of this court has already released the accused persons after going through the arrest memo and the notices where the ground of arrest is not mentioned following Bhyan Kumar. Mr. Counsel, I'm sorry, you're trying your best, but this is not the forum for this.
One more thing, Your Lordship, with regard to what my learned friend is trying to say, that is also incorporated in the judgment, page 14 of the judgment. Justice Koteshwar Singh has specifically indicated in
Page 14.
Justice
I have
Kuteshwar
read,
Singh's
this
part.
is a very detailed judgment.
Yes. Justice Kuteshwar Singh has, in his part, has indicated that. Lordship has got that?
Yes, please read.
Second paragraph.
Yes, please.
The issue on the requirement of communication of grounds of arrest to the person arrested as mandated Article 21(1).
Page 14, paragraph 14.
No, page 14. Justice
Oh,
Kuteshwar Singh's part.
Page 14. Page 14 of Vihan Kumar. How does the paragraph, what is the paragraph number? You are having a Supreme today.
Yeah, this is no. I think there is a different.
Huh?
Just Lordship is looking at the other case.
I had Vihan Kumar.
In that, the one which I gave your Lordship, then it is in last part.
Last part.
In
Why
the
is
one,
it, one second. Why is it not there in my?
it has been given in a
Yes, yes, I've got
separate.
it. I've got it.
Yes, there your Lordship will kindly see the second paragraph.
Yes.
The issue on the requirement of communication of grounds of arrest to a person arrested as mandated under Article 22(1) of the Constitution of India, which has been incorporated in the this is PMLA under Section 19 thereof, has been succinctly reiterated in this judgment. The constitutional mandate of informing the ground of arrest to the person arrested in writing has been explained in the case of Pankaj Bansal Supra, so as to be meaningful to serve the intended purpose, which has been reiterated in Probir Purkasta Supra. So it is not that just mentioned, it has been stated that it has to be written. That is why I am saying. What
They
my
said
learned friend has
communication.
said that it may not be written, but
There is no the scope of going into all this. This decision of the apex court is binding. How can I start interpreting this decision? It is absolutely clear. Tomorrow, if there is a review, something happens, that's a different position. You can take this order of mine after I pass to the apex court and do whatever you want to do.
there are, I think, many authors passed by this order. They have not approached.
I am going to record it, Mr. Locker, but I'm sorry to say I'll have to reject your. Yes, please take it.
No.
Heard Mr. Y.S. Manan, Leonard's counsel for the petitioner, also heard Mr. P.S. Locker, Leonard APP for the state respondent. This is a second bail, right?
This is
a second bail application under section 483 of the BNSS 2023, seeking granting regular bail to the accused petitioner Azibur Rahman, alias Aziz, alias Ajibur, who was arrested on 9/4/2023 in connection with NDPS case number 103/2023 arising out of Pragjyotishpur PS case number 48 of 2023, registered under section 20 within bracket small b, within bracket Roman 2 and then C, of the NDPS Act 1985, pending before the Court of Additional Session Judge FTC number 3, Kamrup M at Guwahati. Where is the first order, rejection order?
that day I have given a copy of it.
It's not annexed.
Not, it has not been, it is mentioned, but I have given a copy of that day.
Is it part of this? No.
So that day I handed over the copy. Your Lordship has gone through that. Not a part of the petition.
You don't have another copy. You don't have another copy. Why is it not annexed to your petition, Mr. Manan? File na वैसे नहीं है.
I don't have a copy.
Give him the reference. You take a printout.
Like
The brief facts of the case is that the jurisdictional sub-inspector of inspector lodged an FIR before the officer in charge, Pragjyoti School PS, alleging inter alia that on 8/4/2023 at 2 p.m. the OC of the said PS have received one information that illegal business of ganja, within bracket cannabis, is going on at Amgaon, Lechuk Bagan in the room of is the petitioner Ajibu of the petitioner. And accordingly, the police personnel proceeded to the said location and started investigation and kept an weigh machine at 2:30 p.m. and found the accused in the room, and the accused led the team to the ganja concealed in a drum. Thereafter, in presence of independent person, police weighed the plastic blue colored drum along with ganja inside it and found the weight to be 22.225 kg. The aforesaid ganja was seized and the petitioner was apprehended. Thereafter, the police, along with the accused petitioner, proceeded to Bonda Bazaar and conducted search. At Ma Kali Hotel of Aradhan Burman and recovered one plastic white color carry bag containing 720 grams of ganja. The co-accused was also apprehended and thereafter conducted raid at the house of another person, but found nothing. However, that person took the police to an abandoned school where one blue color plastic drum containing ganja weighing 16.525 kg was also seized. Accordingly, a case was registered as Pragjyoti School PS case number 48 of 2023 under sections 20B 2C of the NDPS Act. Stop. Accordingly, the a petitioner was arrested and produced before the learned Chief Judicial Magistrate, Jurisdictional Chief Judicial Magistrate on 9/4/2023. And after completion of investigation, charge sheet was filed. After the matter was put up for trial, the trial court took cognizance under section 20B 2C of the NDPS Act and framed charges thereof. Pertinent that, yes, you got it?
Yes.
Pala? Where's the reference of that case? The Manan, in your petition, where have you referred? I have not mentioned about the earlier round. Have they mentioned about the first round or not?
No, it is not there.
But if you have to mention that,
I've asked him why it is not being.
how can it be?
Should have mentioned.
I'm sorry, I cannot do anything. You want to amend it, you can. And I cannot do anything. How can that information be not there in your bail application?
I thought it was there, but
No, it should be there.
that it's not.
एक गुट्टी तो काटी दिया. It appears that this is the second time the petitioner has approached this court pursuant to the earlier rejection of the bail prayer made. However, no reference of the earlier bail application nor the rejection order is enclosed with the petition. Mr. Y.S. Menon seeks accommodation to file an additional affidavit in this regard. Prayer is allowed. When do you want
Yeah.
list on such and such date? Where is Mr. Datta's matter? Hey, number? Sir, Datta,
Yes, I have prepared.
Mr. Locker, you individually verify where that notice is and the arrest memo, because you see that is the only distinguishable fact in the individual cases. It is not that when this ground is taken, automatically the bail is going to be given. It has to depend on the facts of each case. So what you need to see is the notice. Video. Actually, there's a scanned copy. This matter I have seen, but if there are similar more matters, then you please have a look. Here are 50 NDPS for your
Yes.
where is that? Mr. Locker, I'm reading the notice. This is under section 50 CRPC. The person is Kabil Uddin.
Kabiluddin, madam.
Reference so and so case. You are hereby informed through this notice that you have been arrested in connection with the above reference case and will be forwarded to the court being the offense non-bailable to police. You may submit petition before on the honorable court for your bail. Is only that. That is the problem. And not only that, you lay down some strictures in not doing it. If you don't do it, I'm telling you, it can be misused. And arrest memo is there.
My lord, one more point is that 50A, my lord, it should be informed to the family members.
Arrest memo. Yes. The arrest memo also nothing there. Signature, place of arrest, date and time of arrest. Signature of accused is there. What is the other ground that you have taken?
My lord, 50A, it should be informed to the family members. So they can arrange the advocate.
That is also not done.
Not that. Only there is a communication, the police station, you inform him, but that 50,
Have the police informed anything discernible from the records?
50A. It's not there, madam.
See, verify yourself. What I will do is, Mr. Locker, you have a look at these cases, whichever the arrests they are, because I think more cases are there where they are taking this ground. Please verify individually. Let me finish the motions and then I'll take it.
Right.
Not fair to keep the other counsel waiting who has motion matters. Take it out, Ditya. But please, note to return back.
One more time.
Note to return back. Any matters where similar grounds have been taken, please inform. Please inform. No, item 4 is first time. First time, I'm not saying. The ones where there are hearing matters. First time is a different situation. This is also Mr. Manan's matter. I think he was there. All of this. I think they thought it will take time. Yes, but no one is there. We'll call it again second time. Right, I think C is there, so notice and let them.
Only page by the 18, just have a look, my page,
First they indicate Mr. Chaudhary, what can this board do?
short page.
Third, Mr. H.R.A. Chaudhary, Learned Counsel for Learned Senior Counsel, assisted by Mr. I.U. Chaudhary, Learned Counsel for the petitioner. Also heard. N. Kakoti. You are for
And civil.
Standing Counsel NCB. You are a special public prosecutor or standing on. This is an application under section 483, BNSS 2023 for granting bail to the petitioners. To the petitioner, Rashid Haq, who was arrested on 31/2025 in connection with NCB Guwahati case number 2/2025, under sections 8C/22C/29 of the NDPS Act. Issue notice, returnable on given date. A scan copy or case diary?
I think it is case diary because you have not.
That the case diary be produced on the next date of hearing, on the next date. List on such and such date. Extra copy. Issue notice and extra, so and so accepts notice on behalf of DDP. Extra copies within the course of the day.
It is given to her, my. Right.
Within the course of the day. Okay.
Make clear. There was the item number 4 and item number 20 lottery arising out of same FIR.
4 and 20.
Yes. And in 4 lottery, your lottery will find the
20 is an AB.
maybe. In
4
item 4, he was arrested. He is arrested lottery on 20.
assault to women, modesty,
Yes.
extortion.
From the material your lordship will find, all the offences are below 7 years punishment. That Satyendra Kumar unfair case, your lordship, honest Kumar judgment. That if they arrest below 7 years, lordship, they have to cite reason. And if no reason.
Right, notice short date. For, item number 4, na? Third, Mr. A. Ahmed, this call for CD. Call for CD, list on such and such date. I will find, and item number
In item number 20, lordship, I have prayer for interim bail.
20. Same date, 20. Okay, good.
Because in FIR also, lordship.
All right, short date. I got did you?
Outline.
Yes. Sexual harassment. This call for CD.
I think this case, kindly see the FIR.
Bail application, you're not going to get an interim today. Let the case, serious allegations.
My-
Yes, next.
I can
Short date, give a short date.
121. 21. 1. Or 22. 20.
NDPS. Notice and see a call for CD. The format of DP, but M. Goswami, na? MP Goswami, APP accepts. Huh? NDP is given to mention. This is item 7.
Seven.
C, same.
My lord, in this case, the work case has already been granted to premium.
Yes, but this is under commercial quantity.
314 days, my lord.
All right, short date. We will give
22nd, if it's possible.
a notice and MP Goswami and case records, case diary, I will date 20.
22nd.
All right, 22nd.
Stop it.
Notice call for case secretary MP Goswami.
LCR launch. Can LCR.
Scan copy.
Yes, sir.
Then that has to be through registry.
Yes.
Let the scan copy of the case records be called through the call from
From Sri Bhumi, Lordship Special Judge Sri Bhumi. Lord.
call from the jurisdictional court through the registry of this court.
I live.
This is a POXO matter.
That is your lordship.
Informant is a party.
Yes, my lord.
The
My
notice
lordship,
will
the
go.
ground is here, my lordship. Same ground of arrest has not been provided, my lordship.
All
Please note
right, but the
25.
notice has to go. It's a POXO matter.
My lord,
Your name?
D. Hussain, my lord.
Heard Mr. D. Hussain, learned counsel for the petitioner. Also heard Mr. MP Goswami, learned EPP for the state respondent. This bail petition is filed seeking bail to the accused petitioner I. Najim Uddin, who has been arrested on
2nd of August 24. 2nd August 2024, my lord.
where do I get the date here? You have
My lord,
given-
from forwarding report, my lord.
Okay,
page number
on
20.
on 2/8/2024, in connection with special POXO case number 246/2024, registered under section 64 of BNSS, read with section 6 of POXO Act, read with section 67A of IT Act arising out of Lanka PS case number 243/2024, full stop. Issue notice, MP Goswami EPP except for R1, steps in respect of respondent number 2, informant.
Well-
Informant be taken through the registry of this court in accordance with the direction passed by the division bench of this court in the case of Deepak Nayak versus State of Assam in criminal appeal so and so. Criminal is a side of.
LCR may be called. my lord.
Let the scan copy of the TCR be called for through the registry of this court.
The two grounds, my lord. Ground of arrest.
List
and
on such and such date.
my lord. Highly obliged. my lord.
Returnable curricular detail.
Date, my lord.
Returnable
Short date.
notice, returnable.
Huh?
Steps, you have to take steps. The informant
lord,
has to appear.
My lord,
Till the
really,
informant doesn't appear, you're not going to get anything.
my lord.
Yes.
Grateful, man.
Yes, Miss Bora. Criminal conspiracy and theft.
Lordship.
Where is the FIR?
FIR is page 14,
Page?
14, 1/4. May I read, ma'am?
Yes, please.
The officer in charge so and so, reference Durabad Police Station, Billy entry so and so. With due respect, I would like to inform you that when we were conducting Naka checking duty on so and so at Durabad Tinjali in reference of Durabad.
Poll.
Please, okay.
All right,
Petitioner is-
short date. I did read to see if an interim can be given, but not for coal theft. Sorry. I call for CD. MP this one.
Date?
List on such and such date. Short date.
Public.
365.
That clear. There is a POXO matter, lordship, here, the
POXO.
yes, ground lordship that notice were not served. Here also my submission to lordship is that in Bihan Kumar's case, it is said that statutory restriction will not lordship go to grant.
Heard Mr. A. Ahmed, learned counsel for the petitioner, also heard Mr. MP Goswami, learned EPP for the so and so. This bail application is filed seeking bail to the petitioner, i.e. Dulal Hira, who was arrested on 29/6/2024 in connection with POXO case number 101/2024, pending before the court of learned special judge POXO, Morigaon, arising out of Morigaon PS case number 127/2024, registered under section 365 IPC. Issue notice. Returnable on date of the GDPR. Mr. MP Goswami accepts so and so for one in case of R2 notice by registered post a notice steps steps through the I think registry, right? They have to, through the registry of this court in accordance with the directions passed in so and so, huh? And case diary, or let the trial court records be called for through the registry of this court, list returnable date to such and such.
All right.
So 107
So-
also is there.
All right, same thing, খালি ইয়াত
Okay.
petitioner নামটো বেলেগ হৈ যাব আৰু section 2 হ'ব Ajara PS case number 61 of 25, registered under section 107 of BNS, read with section 4 of POCSO, huh? আৰু when arrested on
Arrested on 6/4/2025.
6/4/2025 2025 আৰু নাম তুমি চাই ল'বা. Yes, Mr. Goswami, you wanted to say something? Yes, sir. That's it.
Notice, probably he can accept notice on behalf of the respondent number 2 also, because
No,
is
he
the
cannot,
sub-inspector,
because respondent number 2 is the,
police sub-inspector
yes, but it is by name.
by name.
He is the informant.
Yes.
So, Mr. Counsel, let me tell you, it is not the informant as such. It is the victim which has to be impleaded. You implead the victim, only because here the informant is not related to the victim. So, you will have
This
to.
case, the Tim's family, they did not give any intimation, and police has
be,
motor raised.
But you see, the council, have a look at Deepak Naik's case. This is not correct. What is the name of the victim? How old is the victim?
He was 15 years, he has expired, or 60 years.
Then I am not doing anything. You check. Mr. Goswami.
Or
It would come and modify correctly that it appears that since the informant is the jurisdictional police officer.
Yes.
Police officer, he has been arraigned as a respondent. However, neither the victim nor her family members has been arraigned in this bail application, which arises out of a POCSO case. It is the mandate, the mandate as laid down by the division bench of this court in so and so is that the victim stroke family parent stroke support person has to be arraigned as a party respondent in bail application arising out of POCSO. That being so, however, in the instant case, it is submitted by Mr. So and so, learned counsel for the petitioner that the victim has expired in the meantime. Let the jurisdictional police station, let the jurisdictional investigating officer find out, submit a report as regards the victim. So, let the jurisdictional investigating officer furnish a copy of the bail application and the notice to the family members of the victim and submit a report thereof to the Office of the Public Prosecutor, Assam. You take steps, huh? You take steps through the registry, and thereafter they will do it. ওপৰৰখিনি একেই থাকিব, subsequently block. And list after 3 weeks or 2 weeks.
After 88.
List on such and such. Yes.
POCSO it is there, madam.
POCSO, same, huh? It is an anticipatory bail application. Mr. Borwa,
Yeah, Guru.
K. Borwa, MP Goswami, notice, informant,
Not him.
R1 logo MP Goswami for R2 notice to the registry of this code in accordance with so and so. List after 2 weeks and a date to be fixed to the registry. CD or let the CD be also qualify.
His affair has been registered by CBI also.
CC Act.
PC Act, but he is not a public servant. So they have incorporated 120B IPC. But 20B IPC is not applicable.
Anyway, the allegations are serious, so not, let us have a look at the case diary first.
That is explanation.
Something without,
Bank.
in the meantime, you also,
It can be tag lossy, but my humble submission is that they are not public servant, and here is some explanation.
so, you see, it will be convenient for Mr. Chaudhary because ultimately the case diary will be the same. That is, of course,
what I'm-
you see, whenever there are co-accused, it has to be considered individually. Just because one co-accused gets it or doesn't get it, doesn't mean the other will also, the same consequences for it. It has to be
What I am submitting, there is explanation. If that explanation
not,
can be
not
looked into.
today. Heard Mr. S.D. Purkas,
Forecast.
Learned Counsel for the petitioner, also heard Mr. R.D. Chaudhary, R.K. Dev Chaudhary, Learned Standing Counsel, CBI. Learned, so how does it say the designation? What is the designation? The Deputy Solicitor General. Bengal. AP, call for CD and list on
28,
28 so and so along with
item number 20. Oh, that's not 804.
please, can you ask your junior to give that? Another matter is there today. You have another matter,
Another matter, item number 23.
the same order?
Same order.
All right. It will actually get it. 14 and 23.
Okay.
Yes, please, your lordship. My lord, here in this case, my lord, I have very limited prayer, my lord, of transit bail for a period of 1 month, my lord, because the notice has been served from Sen Police Station, Bangalore, my lord. My lord, in a case of, my lord, the section charge, my lord, 66 D, C and D, my lord. Kindly see the notice, my lord. Case 12, my lord. Two petitioners are there before your lordship, my lord. Case 12 is one notice, my lord, that is sent to petitioner, my lord, under section 94 and 179 of BNSS, my lord. And thereafter, my lord, the petitioner given reply to the said notice, my lord. Thereafter, again, second notice has been sent, my lord. That is page 13, my lord. Under section 35(3) of BNSS, my lord. 35(3) of BNSS, my lord. Ask them to appear before the concerned police station within 7 days, my lord. My prayer, my lord. I will appear before the concerned jurisdictional court. But I have to obtain certified copy there, my lord, and to file, my lord.
All right, let an opportunity be given first. I'm giving a short date. Item number even 15 now.
My lord, this case is from outside, my lord, from outside Assam, my lord.
Who is appearing? You have said PP Assam is
No,
there?
no, no, my lord. Here, my lord. I am praying for transit bail, my lord.
Other side is who?
Although I have mentioned them,
Oh,
my
it's
lord,
the state of Assam. There you have made a party.
although I have made party, my lord, but my lord, in a transit,
What do you mean? Although you have made a party,
my lord. The lordship,
you have not made the correct party,
my lord,
Mr. Goswami.
I cannot. No, no. Kindly have a look, my lord. I have
Correct, but it is registered where?
Bangalore, my lord.
Then you have to file it in Bangalore.
My transit bail provision, my lord. Kindly, my lord, have a look, my lord. Our High Court also, my lord, granted bail in this. I have one order. Judgment I have given my recent judgment by the apex court, my lord.
How can this court grant transit bill without going into the, what is there, without hearing the other side?
I kindly see, my lord, the Supreme Court judgment, my lord, passed by Honorable Justice V.V. Nagaratna and Honorable Justice Ujjwal Bhuyan, my lord. Para, my lord, your lordship may kindly see. Paragraph,
I am not convinced this matter will
kindly
have
see,
to
my lord.
be heard. I'm fixing it after reopening.
paragraph
You
30
have a look at it. Mr. Goswami, you can also assist the code even if you are not the person. Just assist the code.
my lord, one
As
minute,
prayed
take-
for list on
my lord, can I take one?
first day of the oath,
My lord.
21st.
Your Honor, kindly pass over the matter for timely. I am for the on behalf of Mukut Soikia. I am on behalf of the Mukut Soikia. Your Honor.
Okay. Timely. Four, what is this? 420. Let us see FIR.
Yes, my lord, I am not named, in fact, I am a victim itself. It's similar
Not
to that.
name.
No, my lord, in fact, I am a victim insofar as it's similar to the informant.
Let's see.
Page 15,
FIR page.
page 15. As per enclosed documents and above, we paid 27 lakhs to the said persons.
Where are the contents of the FIR?
Here, Milord, it starts from Milord 15. It was Milord initially to the Deputy Commissioner of Police, which was forwarded to the Chanbari Police Station.
Yes.
And the lordships will find the name below, the names of the accused persons.
Who is you? You're not there.
No, no, I'm not.
You're not. All right, what
I
are,
am a company. I was the director of a company. Certain work order.
you are the director of the company.
Yes.
Let's just read the contents
Got you.
one.
Got you. As per enclosed documents and above subject, we paid 27 lakhs to the said persons for advance commissioning against the purchase order. We found the purchase order copy enclosed is fake and fraud, issued by Deepak Kolita's house, Chanmari near Bhaskar Vidyapit, Guwahati by Rishiraj Kundial Deepak Kolita.
You are none of them.
No, no. Biju Das to Amrik Karbi Development Council, Tripinaya, Guwahati. It is also bringing to your notice that we supplied dried cotton yarns to Amrik Karbi Development Council of rupees.
You are the
50 lakh.
director of which company?
Not here, Lord. Lordship, I'll just come to it. Lordship will kindly come to page 17. This is on the basis of which this FIR was lost, Lord. It was a fake order. The allegation is this: on the basis of a fake order, certain supplies were made, payments were not made. They did not receive the payment. That is the contents of the FIR. The similar order, Milord, I am a victim at page 18.
Now, in this also, there is no reference of
No, no,
it.
no, Milord. Look, what has happened, Milord?
Which is the company, this seems it has come from
Here, Milord, page annexes,
page 17 you are saying, na?
page 17 is the work order, Milord, the fake order or order on the basis of which the informant supplied materials to the.
No, but page 17 is an order of government of Assam.
Yes, Milord. It was enclosed with the FIR. There's a part of the FIR.
On the basis of this, the order was done.
Order was
But
placed.
this is a fake order.
Yes, Milord. They supplied materials.
Okay, and now next,
Now, Lordship will say, same order was given to me at page 18 for supply of mosquito nets.
you appear.
I will appear, Milord. That is what.
Let him appear, Mr. Goswami.
In fact, Milord, I have filed a suit before the, Milord, that your Lordship will find at page 29. No, apprehension is page 48.
Right?
Page 48 is the notice, Milord. 41A notice.
Oh, page 48.
48 is the notice, Milord, whereby I have been asked.
Because otherwise it appears there is nothing against him,
Nothing is.
isn't it?
In fact, the date is fixed on 17th, Milord, for appearance. It was earlier fixed at 29, Milord.
Which is the other document you were showing, I didn't get it.
Lordship,
Page
page
where
18
you
was.
wanted to show you were a victim.
Well, page 18 was the initial order by which certain base, Milord. We did not receive the payments. Milord, the Lordships, I have enclosed even the bank does, Milord, I paid 20 lakhs as demand draft.
Okay, slowly.
Lordship.
Because
Milord.
see, you know the facts. I don't, I have
I'm
to
sorry,
put
I'm sorry.
something in the order.
Milord, what had happened, Milord? 1 crore 50 lakhs, Milord, was the amount. Against which, Milord, earnest money of 20 lakhs was paid, which your Lordship will find at page 20. And Milord, there is a receipt on page 21 that they have acknowledged 20 lakhs rupees, Milord. Now, Milord, thereafter are the challans which I have produced. The goods were supplied. I did not receive the payments. Thereafter, my lord, I file a suit at which your lordship will find at page 29
29.
for recovery of the amount. This is the plaint which was filed in the Civil Judge Senior Division at Purulia. Now, it proceeded ex parte. And in fact, my lord, page 39,
Heard Mr. R. Dale, Learned Counsel for the petitioner, also heard Mr. MP Goswami, Learned APP for the state respondent. This is an application under section 482 of the BNSS 2023 seeking grant of seeking pre-arrest bail to the petitioner, i.e. No, but this Gopal, this petitioner, he's not named. So that is why I'm giving him only an interim bail. Let him appear. You investigate. If there is something, we will not make it absolute, isn't it? Because otherwise, it's a case of why should we not grant an interim bail where it is deserving? Petitioner Namtura Asana. I, Gopal Kumar Saraugi, who is apprehending arrest in connection with Chanmari PS case number 214/2018, registered under sections 417, 420, 468, 34 of IPC so and so. Call for the case diary fixing the matter on so and so. Considering the facts and circumstances of the case, it is provided that in the event of arrest, the petitioner named above shall be released on interim pre-arrest bail in connection with the above noted case on furnishing bail bond of rupees. Yes. How much bail bond? 20,000? 15,000? 50,000? 30,000? 30,000 with one surety of the like amount to the satisfaction of the arresting authority, subject, of course, to the following conditions. 1, 2, list on 1, 2, 3, list according.
I will appear on 17th. I will appear on 17th because 17 is the date fixed for appearance.
17.
Look, we took with short time, and the 17th was fixed. So, in terms of
On
41.
the day, where is that notice?
Notice was at page 48, I was directed to appear on 29. I sought time and it was fixed on 17th.
That is not here, no?
No. But I have made a statement,
Petitioner shall appear before the investigating officer on
17.4, paragraph
17
17.4,
4/2025, failing which on and from the 18/4/2024, the interim pre-arrest bail order shall have no force. Paki duta lagi bro.
Page 9 is the affair.
House trespass, theft, and stolen property.
But we are the consumer and we have been given home delivery by the accused number 1.
FIR.
Yes, page 9 minutes. And accused number 1 already been arrested and he has been released on bail. Accused number 1.
You are number
We are number 345.
345. Please read the FIR.
I have the honor to state that the above noted accused number 1, with the help of the other accused person, has been stolen from shops and house to me Patagata Monitor for a long period. The stolen items were kept
These stolen things were recovered from the house of accused number 1, who is already on bail.
yes.
Which is that order?
My lord, we have annexed the my lord, regular bill, page 16.
It's 16.
Page 16, my lord. The court order is there.
Let him appear, isn't it? Yeah, Argon is no order. You appear on the 10th, 7 days. And the 8th day हो जाएगा और बाकी एक नहीं आपका फाइनल and up to this is item number 16.
18.
18. Mr. M.U. Mondal, FL MP Goswami. Okay, so details to the work. South Salmara, PS case number 189, 2024, under section 3314 205 3172 PMS. Nam, who is apprehending the petitioner Nam Bhutan Namasan, Anwar Hussain, and Mostafizur Rahman. Back bail bond each of rupees 30,000 per each. Worried about 10 days, 11-day failure. Yes. List on call for failure fixing. Yes.
This is anticipatory bail application lordship. The FIR pays lordship 11 lordship and all of the section under punishment of 7 years lordship. So I am ready to cooperate with investigation officer lordship. I pay for interim protection.
1 second, let us see the allegation. Talks about some syndicate and all. Parking fees.
Yes.
Page 11.
Page 11 is the FIR. One news item was published. On basis of news item, police register a case against us lordship.
Have a look, Mr. Locker. I think
I am ready to cooperate with investigation authority lordship. I will appear. And 5 accused persons are
1
arrested.
second, let the APP have a look at it. Based on the news
Based on the news lordship. And
that they are collecting parking fees illegally,
Illegally.
600 to 800.
And lordship, in this case, lordship, 5 persons were arrested by the police and London Judicial Magistrate already released on them bail because nothing was found against them. Lordship. No, after 14 days custody.
Quick.
After 14 days custody. That forwarding report is also available, lordship. I have annexed.
1 second. Why are you getting so
Sorry, lordship.
anxious? Just 1 second. I think they can appear, Mr. Locker. Third, Mr.
US Borg.
U.S. Borgoya, Learned Counsel for the petitioner, also heard Mr. P.S. Locker, Learned APP for the state respondent. This application is filed under section the first title is not very happily worded. It is filed under section 482 of BNSS, seeking grant of pre-arrest bail to the petitioner, i.e. Naru Ali, who is apprehending arrest in connection with Bukista PS case number 174/2025, registered under section 61 within bracket 2, 318 within bracket 4, 308 within bracket 2, 30 types of comma 8 within bracket 4, 351 comma within bracket 2, 351 within bracket 3 of BNS 2023. Stop. And call for the case diary fixing on Fixing the matter on 5/5/2025, considering the facts and circumstances of the case, it is provided in the event of arrest. He was 30,000 with one surety of so and so. Appearance 10 days.
Within 10 days.
But you took that in the list accordingly.
Highly obliged.
OXO is there?
Yes.
It took notice jump over. Heard Mr. A. Hussain,
Yes.
learned APP, learned counsel for the petitioner. Also heard Mr. P.S. Locker, learned APP for the state respondent. Since this this anticipatory bail application arises out of a offense of an alleged offense under the POCSO Act so and so, let notice be issued. Let notice be issued. So and so accepts notice for one. In two is the informant.
Fine.
In respect of the respondent number 2, who is the informant, let notice be issued through the let steps for issuing notice to the informant be taken by the petitioner through the registry of this court in accordance with the directions passed by the division bench of this court in the case of Deepak Nayak versus State of Assam in so and so. List
Scan copy may be followed.
let the scanned copy of the case records be called from
Special as Sub-Summer Mantas.
be called from the jurisdictional court
Sub-Summer Mantas.
through the intersign of Please give it in a piece of paper. He'll put the court name. Verify and give it.
Yes.
Right now, I wrote through the registry of this court. Yes.
482 application.
Cattle preservation.
Can you see at FL?
Huh?
Can you see FL?
It will be required. Where is the FIR?
At best 10 lots. I am getting up. Would you respectfully that registered that on 2025 about 3 o'clock night, I was woke from sleep and went to out and seen that my 2 cows were not available in the
Cows. And you were driving that vehicle which he
But-
suspected. Huh?
but I am
Him appear, Mr. Loker.
but I am not owner in this car.
Huh?
And I am the not owner in this car.
That is a different thing. Is he named in the FIR? Huh? He's not named. So let him appear. Let him appear. Itu hey, your name?
R.I. Mandal.
Third, Mr. R.
R. Mandal.
I. Mondal, learned counsel for the petitioner. Also heard Mr. P.S. Locker at APP for so and so. This is an application under section 482 of the BNSS 2023, seeking grant of anticipatory bail to the petitioner I. Safiqul Islam, who is apprehending arrest in connection with the Pokrajar PS case number 36 of 2025, registered under section 3032 3174 BNSS, read with section 13(1)(16) of the Assam Cattle Preservation Act and read with section 11(1)(d) of the Preservation of Cruelty Animals Act. Call the case diary, fixing the matter on 5 so and so. Episode 2 একেই হবো, খালি that's why let him appear. If there is nothing, we'll dismiss it. At least let him appear, isn't it? On 5th. And there must be something, otherwise, what is your apprehension? Based on what? If you're not the owner.
Another 2 RC lottery.
Huh?
Page 16. Registration.
What is this? Registration of the car.
Registration of car, owner is the Mokibur Hussain.
No, but that is not you. Why are you apprehending arrest?
Doubtfully,
Huh?
doubtfully,
What doubt? Why are you apprehending error? You have to tell me why you're apprehending errors, otherwise I'm dismissing it.
Chief, I am the actually businessman of the
What
vegetable shop
businessman?
from Pokrajar market. Lord.
Where have you stated on oath about your apprehension? Where have you stated on oath about your apprehension? You have come before this court seeking anticipatory bail. What is your apprehension? You say you're not the owner. You have enclosed the document. Owner is someone else. Your name is not there in the FIR. Just because you are a businessman. Why are you apprehending that the police is going to arrest you in connection with this case? Where have you stated in your petition? If there is no apprehension on how is this anticipatory bail application maintainable? You don't know. You don't know.
Actually,
Huh? What actually? Counsel, please be mindful where you are standing. You cannot so in a routine manner file anticipatory bail application. There could be merit in this case. The stakes are very high in such applications. But you must be able to visit the court and answer the queries. You file the petition. Which paragraph, Mr. Locker, anywhere they have stated?
no. There are 7.
So his house was visited. That is all that you need to say. The APP has to do your job. But 15,000. No, 30,000. And 10 days. You appear within 10 days. Otherwise, on the 11th day, the interim bail will have no force. This date to dinner. Yes, Mr. Manan, this
Make
is
this, your Lord. This is a
again
483.
21C.
This is-
21C.
No, this is 21 B. Yeah, C. 21C.
So, case diary
Depends.
or what? Scan copy or case diary?
Yeah, the same issue as that issue has been taken for search-sheeted case.
Then
There
scan
are
copy.
14 listed witnesses. No, none of them examined.
All right, Mr. Manan, first we'll have to call, give them an
I'm not-
opportunity. Heard Mr. Y.S. Manan, counsel for the petitioner, also heard Mr. So and so, if it is a state respondents, issue notice, fixing the matter on such and such date. Call for the call for extra copies to so and so within 2 days from today. I will call for the scanned copy of the case records from the court of
Additional session judge number 3.
additional section
Kamrup
judge
Metro
number
1.
3, Kamrup Metro, through
One.
the registry of the of this court.
Thank you much. In this matter, your lordship, this is
You are appearing in two.
my learned friend has requested me to appear in this matter.
21B.
This is B. Already
But,
42 days
Bail,
have
this is bail.
42 days have elapsed.
All right, we'll give you a
It is
short date.
60
We'll give you a short date, Mr. Manan.
period is 60 days.
Heard Mr. Y.S. Manan, learned counsel for the petitioner, also heard so and so. Issue notice with fixing the matter on, give a short date on such and such date.
Because on that day, otherwise it will be the period will be over 20.
On 22. What is to be called?
CD. In this.
Let this and call for CD for CD. Extra copies, give him extra copies.
In this matter, my lord,
Case has been registered under section my lord.
Abatement of suicide,
Yes, my lord. Abatement of
fire,
my lord, FIR is at page my lord 11. Type copy, my lord. My lord, here it is stated, my lord, with due respect, I would like to state that my daughter, namely Miss Sumya Narzari, is 19 years, is studying at the fourth semester of Procedural Doctor College and stays at a rented house at Bagan Sali, ward number.
Mr. Locker. No, CD is required, but appears he was the boyfriend. And allegation is that he was blackmailing by threatening her with some photographs and all. I'm not saying, but think he can appear. Hmm? Can appear. Let's see what comes out. If something is there, we'll not make it up. Third, Mr.
M. Soikia, my lord, I am on behalf of PK government.
M.
M. Soikia, my lord,
This is item number
16, my lord.
M. Saikya, Learned Counsel for the petitioner. Also heard so and so. This is an application under section 482 of the VNSS 2023 seeking grant of pre-arrest anticipatory bail to the petitioner I. Vivek Brahma, who is apprehending arrest in connection with Pokrajar PS case number 59/2025 dated 22/2/2025, registered under section 108 of the VNS 2023, read with section 67, 67 B of the Information Technology Act 2000. Call for the next stop. Call for the case diary fixing the matter on so and so. Bail bond of rupees 20,000. 7 days.
15 days.
No. Appear 7 days. Allegations are otherwise serious. It is only that I am giving you so 7 days. 7 days failing on the 8th days. Cancel. But if you did yes, accordingly.
Apply to it.
Yes. '24, '26, and '27. Okay. What about 25 and 28? That is in a little different footing. Which one? Which one? TCR has not been received in item? Item 25, who is the counsel? CD is awaiting. So in item 25, await CD list on.
And FSL report, my lord. Actually, last time CD was received, but it has sent back.
Then you wait for the turn. Let me finish with Mr. Doctor. He's been waiting since 10:30. I thought I would have released you because it's just a one line order for you.
Appreciate, lord. That may be done.
What has not come? Awaiting so and so report list. Item 25. We got. Yes. What about 20? All right.
Flush.
Come 24 sir. Point order all of select facts it will be first 24 to 1. Heard Mr. NG Datta, Learned Counsel for the petitioner, also heard Mr. P.S. Locker, Learned APP for the state respondent. Take your seat, counsel.
Pardon.
This application is filed under section 483 of the BNSS 2023, seeking grant of regular bail to the accused person, accused person, accused petitioner will go your Kabel Uddin and Sabur Ali, who has been arrested on 9/5/2024 in connection with special NTPS case number 74/2024 being registered under section 21C 29 of the NDPS Act so and so pending before the court of Learned Special Judge Kamrup Amingao. Arising out of the Boko arising out of Boko PS case number 198 stroke 2024 registered under section 21C stroke 29 of the NDPS. Now, the gist of the matter is that on 9/5/2024 at 9 AM, the complainant lodged an FIR alleging that on 9/5/2024, he received information that two carriers were carrying narcotics from Silchar in Alto car and the same would and they would deliver and that they would deliver the narcotics at Boko PS area. So, based on the it is the further case of the prosecution that based on the aforesaid information, the team, the police party went to the location and upon tracing the vehicle, which that tried to apprehend the same. However, the vehicle escaped towards Guwahati, and after chasing the vehicle for a long time, the said vehicle was finally intercepted near Hajo PS. Upon intercepting the said vehicle, two occupants were found, and on being the two occupants are the petitioners. Yes. Two occupants, the petitioners. Petitioners were found, and on being questioned, they admitted that narcotics contraband articles were hidden inside the driver's steering column. It is the further case of the prosecution that upon checking and opening the said portion, 30 soap boxes containing as many as 30 packets of suspected heroin was found, and the same was seized in presence of witnesses and weighed. And accordingly, the vehicle and the weight was 347 grams without soap cover. Accordingly, the vehicle and the contraband articles were seized, and the accused petitioners were apprehended. Thereafter, the case was registered. Mr. Datta so and so submits that the petitioners were arrested without following the constitutional safeguards provided under Article 22(1) of the Constitution of India. He submits that the ground of arrest is not disclosed as required under the law to the petitioners at the time of arrest. He further submits that the provisions that the safeguards as contained under section 50 and 50 capital A of the CRPC has also not been complied with by the arresting authority. And hence the arrest is vitiated and the petitioners are entitled to be released in the forthwith. Stop. Per contra, Mr. So-and-so, learned APP submits. He further relies upon the following decisions. Number one, just on your page 409. Further relies on the following decisions. 9th decision. Per contra, Mr. So-and-so APP vehemently opposes the prayer for bail and submits that yes, what is your submission? Submits he submits that the mandate of Article 22(1) is to inform is only to inform the arrested person as regards the what to inform as regards the ground of arrest, and the same need not be in writing. That's what you're trying to say. And it is not mandatory that the same be written in the notice or the arrest memo. Stop. In support of the aforesaid submission, he relies upon the decision. Yes, which are the two decisions you have given? 1 second. This I think you had given, no? He took it some give. He relies upon the decisions of the apex court in the case of, where is the party name? State of MP versus Shobharam and others. Reported in AI 1966, Supreme Court 1910. Which paragraph? 20. And the decision of the apex court in the case of DK Basu versus State of the West Bengal, reported in 1997, 1 SSC 416. Yes, which paragraph? Huh? 17. And yes. 2022. Yeah. 26. All right. I have given my prudent consideration to the arguments advanced by both the learned counsels appearing for the contending parties and have perused the materials available on record. I have also considered the case law cited at the bar. It appears that the ground it appears that the petitioners were arrested in the case in question after recovering the contraband articles from their possession. It further appears that the charge sheet has been submitted against the petitioners. However, the trial has not started. However, the trial has not yet commenced. It appears that the ground taken in this bail application is that Article 22(1) of the Constitution of India was not followed, and Section 50 and 50A of the CRPC was not complied with by the arresting authority. So, Constitution of the CRPC. Article 22 of the Constitution of India reads as herein, quote unquote. A perusal of the aforesaid provision, it is apparent that no person shall be detained in custody without being informed as soon as may be of the grounds for such arrest, nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice. A bare perusal of the aforesaid provision indicates, amply demonstrates that it is the fundamental constitutional right of an accused to be informed of the ground of arrest at the time of arrest by the detaining authorities, failure of which such constitutional safeguards guaranteed under the Constitution of India vitiates, gets vitiated. So, apt to refer to Section 50 and 50A of CRPC, which reads as hereunder. Yep. Quote unquote 52 deliver and 50A deliver. Reading of the aforesaid provisions under the CRPC further is apparent that it is the duty of every police officer or other person arresting any person without warrant to inform the person arrested of grounds of arrest and right to bail. It further appears that it is imperative for such officer Also to inform such grounds of arrest to any of the to the family members or friends or other persons as may be disclosed or nominated by the arrested person. Undoubtedly, since the offenses under the NDPS Act prescribe stringent punishment, hence the compliance with the statutory prescriptions and procedures under the NDPS Act undoubtedly just I'll come back in 5 minutes.
Fine. If I goes to some other court, my friend.
Yes,
is
yes,
not-
no problem.
not
You can-
otherwise.
You can please carry on. One decision of a coordinate bench which
Yes, my lord, that is my lord. Serial number 6, my lord. Justice Thakuria, my lord. Paragraph 13. Yes.
all right. What?
And on the
Already given that submission. You relied. In order to in order to in order to in order to last but in order to examine the above stated ground apt to refer to the notice issued to the accused petitioners Where is the notice? Uh, this flag mark which you have given is the arrest memo. Because the what arrest memo? This one. No, I was looking for the notice under section 50. I've got it. I've got it. To the notice issued under section 50 CRPC to both the petitioners. Upon perusal of this can be reproduced. This can be reproduced. Apt to reproduce the relevant extract of the aforesaid notices issued to the two petitioners, which reads as hereunder, quote unquote Koriba. It took my here. Green flag at the page, the green flag put our next page of paradise. Perusal of the aforesaid two notices. It is apparent, it appears that the petitioners were merely informed that they have been arrested in connection with BOCO PS case number 198/2024, registered under section 21C/29 of NDPS Act. And that the offense is a non-bailable one. And that the petitioners may submit and as regards the right of the petitioners to apply for bail. Apt also to refer to the arrest memo of the two petitioners, which reads as hereunder. Green flag at Baba, page 13 and 14. Perusal of the arrest memo also indicates that except the reference of the case, no other information as regards the case is available in the arrest. Where is it written that family members police too? Can just point that out one. Thus, it is admitted position that the grounds of arrest were not intimated to the. Thus, it is the admitted position that the grounds of arrest were not intimated to the accused petitioner or to his family members at the time of his arrest, which is a statutory right of an accused, and it is also a constitutional mandate that the person should be intimated regarding the grounds of arrest under which they were taken into custody of police. Into paragraph of report. Apt also to refer to the WT message, which reads WT message issued by the OC Boko police station to the OC Borpeta police station in connection with the aforesaid case, which reaches here under quote unquote corridor, a green flag. It appears, a perusal of the aforesaid WT message appears that the OC Borpeta police station was asked to inform the family relatives of the accused arrested persons. However, whether such ground of arrest has been communicated to the family members of the accused persons was or not is not available in the case diary. The contention of the learned counsel for the petitioner that the accused petitioner has the fundamental and statutory right to be informed about the grounds of arrest in writing, and copy of such written grounds of arrest have to be furnished to the arrested person as a matter of course and without any application. And that non-supply of written grounds of arrest to the accused petitioner would vitiate the arrest even if the case has been charge sheeted. This brings me to the contention of the learned counsel. Reference is made to the decision of the apex court in the case of Probir Purkasto Supra, wherein the apex court in paragraph numbers 19, 21, and 48 has held as hereunder. Unquote. Reference is also made to the decision of the apex court in Vihan Kumar Supra, paragraphs 2012, 13, 14, 21, is reproduced hereunder for ready reference. Apt also to reproduce paragraph 2 of the code of the concurrent finding of the, this was 2 judges, of the second judge in the aforesaid case, which reads as hereunder. Paragraph 2. Paragraph. Apparent reading of the aforesaid judgments of the apex court, that the apex court has clearly held that the grounds of arrest must be provided to the arrested person in such a manner that sufficient knowledge of the basic facts constituting the grounds is imparted and communicated to the arrested person effectively in the language which he understands. And the same shall not be curtailed by any statutory restrictions contained in any other statute. It is further apparent that the apex court has clearly held that the constitutional mandate of informing the grounds of arrest to the person arrested in writing has been explained in the case of Pankaj Bansal so as to be meaningful to serve the intended purpose, which has been reiterated in Prabir Purkasta. In the instant case, as discussed above, there is no mention of grounds of arrest in the notice issued to the accused petitioners, nor there is any mention about any other particulars of the offense. This brings me to the argument of Mr. So-and-so at APP to the effect that the grounds of arrest need not be in writing. As laid down by the apex court in D.K. Basu, Supra, and Shobharam Supra. Where is it said that it is not required in writing? Paragraph 17 and 35 of the aforesaid judgment is reproduced hereunder for ready reference. A careful reading of the aforesaid paragraphs does not indicate that the apex court has explicitly held that the ground of arrest as required under Article 22(1) of the Constitution of India has to be in writing. Need not be in writing. The argument of Mr. Locker so-and-so that the language used by the apex court is that the arrested person has to be told, cannot be inferred that same has to be in writing, cannot be accepted by this court in view of the subsequent judgments of the apex court, which clearly has held that the grounds of arrest has to be in writing and giving sufficient particulars of the offense with which he is arrested. It is the opinion of this court that unless the ground of arrest is communicated in writing with the particulars of the offense, the constitutional safeguard under Article 22(1) of the Constitution of India would be a mere formality and will not serve the purpose with which the framers of the Constitution has provided such constitutional safeguards to an arrested person. No. For the aforesaid reason, the decisions cited by so and so has no relevance to the facts and circumstances of the present case. In view of the totality of the facts and circumstances of the case, it is the opinion of this court. Yes, in your case, how much time you were in jail? I don't know. Okay, and especially in the case in the facts and total of the case, it is opinion of this court that considering the fact that the grounds of arrest were not communicated to the petitioner or mentioned in the notice issued to the accused petitioners under, that is like section 15, notice, under section 50 CRPC, comma, and the arrest memo, this court finds it a fit case to extend the privilege of bail to the accused petitioner. Accordingly, it is provided that on furnishing a bail bond of rupees 50,000, 50,000 only with two sureties of like amount each, each, provided that one surety has to be a government servant to the satisfaction of the learned. Additional, please give me the Session Judge Kamrup Amingao, the accused petitioners, Special Judge Kamrup, Amingao, the accused petitioners, namely Namgita Lagira Didiba, be enlarged on bail subject to the following conditions: 1, 2, 3, 4, NDPS or in terms of the above, the bail application stands disposed of. Now, this takes care of one. Which is the other one? 1 second. 25 to, we have already passed that order. 25 order is gone. Now 26 to 4. 26, 27 relates to the same. The 26, 20, So, but different parties, different case. So that changes will be that. So to me, 20 advocate in 26 is Mr. H.R. Chaudhary. H.R. Chaudhary. Senior counsel, not senior, sorry, HR Chaudhary, আৰু ইফালে PS law কৰি থাকিব। Case details to change over. Mr. Counsel, once the orders are typed, you don't leave now. You wait. Because as for 26 and 27, you have a look at the draft order. I don't want any, because what happened is that when we give orders like this, sometimes one or two something, is missed out, or it could be there could be a mistake. I don't want anyone to suffer because today is the last working day before the vacation. Will you please wait, verify the facts of your individual case, and then confirm it to the bench master. All right? Have to be.
British, I have that much.
Huh?
And LCR, I have that.
PCR দিব এইটো petitioner নামটো change কৰি দিবা special case NDPS case number হ'ব 66 of 2024 arising out of RK Nagar PS case number 84 of 24 registered under section 22C 25 29 of NDPS ঠিক আছে এইখিনি তুমি details পাই যাবা কিবা দিগদাৰ হ'লে মোক দেখুৱাই facts or case to get কৈছা সেইটো paragraph 2 পৰা লিখিবা paragraph 2 আছে হা arrested on 10/9/2024. A petitioner. Ding. How many notice?
Yellow color.
Yet a notice to a yellow. Baba, because notice is under 22.
50 cents.
Huh?
50 cents.
So color is not 50. Oh, they have actually it is that only, but ঠিক আছে yellow color notice at a notice থাকিব আৰু arrest memo is there.
Not there, but it is inspection memo.
Huh?
This is inspection.
Memo. Inspection. দুটাই দি দিবি বাকি লেখাখিনি সব সেম থাকিব আৰু এই 50 নোটিছটো দিবা in fact in this one the right to bail is also not given. That right to bail or কথা লিখিব নালাগে that is also not mentioned. It simply is you are hereby informed that you are arrested in connection with the above reference case as it is non-bailable to.
Very good.
Add a line here. Here is that it is that the notices under section so and so the notices of issued under this is under section 50 only. 50 of CRPC are used in a very casual and mechanical manner by the investigating officer. It is highly depreciated, such approach of the investigating officers while dealing, while arresting the accused persons, which concerns.
One fact I would like to place. The petitioner arrested on 10/9/2024. Section 50 CRPC notice is issued. However, my lord, from 1/7/2024, CRPC already gone from BNSS count.
So then, sorry, yet CRPC section. Then should I quote the section from BNSS in your
No,
case?
This is my submission is that 50 CRPC notice is not at all tenable the eye of law, this notice. Because already 47 BNSS is coming to existence. 47 come.
47. So 47 BNSS. It case of to me 47 CRPC to quote forever. Not 50 will put 47 of BNSS, right?
No, my lord.
No, but it is not mentioned here.
I just should have furnished 47 BNSS.
Correct, but in this notice, there is no mention of any provision of CRPC.
Yes.
No, it is not there. Have a look. That's what I was trying to find out. See, I may be wrong.
Yes, but I have seen it.
I couldn't find it. It is not mentioned.
It is not mentioned, ma'am.
But here it will be what, 47?
47 BNS.
So then let me quote 47. 47 BNSs. Huh? Yeah. Next. After that, 27. Who is there in 27? 27. Thank you. Have you checked? Mr. Gogoi? You know, it is very sad how casual, and if you see those forms, these looks like computer typed forms. And the same forms are given to everyone. Then you instruct them properly. And I think Mr. Gogoi, now of course, because of Rehan Kumar, series of cases will come where they take this ground. Sometimes the IO may misuse the power also. Because this will give a leverage to the accused to get bail. So you have to come up with strictures. They cannot they cannot tinker with the fundamental rights of an accused person in such casual and mechanical manner. And that too in cases of such grave nature. Isn't it? You have to make out. I appreciate the argument put forward by Mr. Locker, but this is the, it appears that he has burned a lot of midnight oil. But you see, this is not the place where this argument can be now appreciated. Yes, in this case where
Chief, conducting down to the is out of station, so the letter shall be passed over for the day, Lordship.
it's so sad. It is so sad. But sometimes these the junior council just do not follow what is happening. Just see. As prayed for by Mr.
J and Suwai.
Huh?
J and Suwai.
Your name.
Lordship. My name is.
So and so. List this case after 3 weeks on a date to be fixed by the registry.
Obliged, Lord.
Very, very sad. Because of you not following what is happening. But you see that this is our constitutional safeguards. It cannot be dealt in such a manner. The entire purpose is to let the accused person know. Simply saying so and so case will not do. And of course, now it has to be in some written form. Because otherwise, how will you prove it because you see the burden lies on the investigating officer to prove that the grounds have been given. Isn't it? Once this question is taken, it is his burden. Now, from the case material records, is it discernible that this have been given? Then but despite that, the court said it has to be in writing. In your case, even those are not there. court scan copies were usually the records video. Yes. Yes. Why is this 20? Notice completed. So this matter can be fixed for admission or hearing.
And your lordship.
It appears that notice in respect of respondent number 2 it appears from the office note dated 8/4/2025 that notice in respect of respondent number 2 is completed. List this matter for admission, I think. Revision petition? Huh? Admission, because it's not admitted. For admission on a date to be fixed by the registry. Yes. after 2 weeks.
The petitioner has faced some kind of blackmailing from the informant. And I have lodged an FIR against the informant at first level.
Ms. Counsel, your matter has been adjourned. Let it come at the time of admission, you make your submissions.
Then 21. 21.
Yes. You have submitted some written argument.
Indeed, Lordship. The written
We'll have
argument
it
was-
after the vacation. Mr.
as well-
Borua is not here also right now. Have you given a copy of your arguments to Mr. Borua?
No, Your Lordship, we couldn't get a hold of them.
No, you give it.
We'll make sure.
Mr. Your name?
Tanuj, Tikashubra.
Mr. T. Kaisha, Learned Counsel for the petitioner has submitted a copy of the written arguments on behalf of the petitioner. Let a copy of the same be also furnished to to the respondents, to the Learned Counsels appearing for the respondents. Relist for further hearing. Any date, particular date?
Lordship, on the 28th of April or 29th?
28, 29, the full, Rupak, 28 or 29? 29 also and so. For the fair. On top, you said, heard Mr. T. Kaishyap, Learned Counsel for the petitioner. None appears for the PCB, na? For PCB on, PCB isn't it? For PCB respondent on call. With that, huh?
That's all right.
Sorry for this. Lordship, actually, item number 28, definitely fifth, Your Lordship.
You have already said, we have said after 2 weeks, the date will be given by the registry.
One minute.